There's nothing more thrilling than nailing an insurance company.
And the truth shall set you free!
I want the truth! You can't handle the truth!
Great moments are born in great opportunity.
All right, welcome back, everybody, to another episode of On Justice Podcast. I'm Jordan Redavid, and joining me, as usual, is my law partner, John Fischer. Hope you're doing well. There has been a bit of a hiatus in the normal output of our podcast production, but it's with good reason. We've been super active in trial lately, and everybody's busy with courts and hearings and depositions and the like, but we're a trial firm, and so when duty calls, we got to go. This year, actually, John, I was just looking before we jumped on the air. I've done 5 different jury trials. I think as a firm, we've done 6. You've been in most of the ones I've done, all of which in Florida or the USVI, and we've had some pretty good success. I just want to stop and talk about, I guess, the most recent one we had, which was the first time for me. I don't think you had done it either, which is like you're trying 2 separate lawsuits that have been consolidated for purposes of trial. And by way of background, although we're going to get into the weeds a little bit, just to have some context, this was a case in Miami-Dade, Florida. It involved a car accident where we represented both the driver and the front seat passenger, and they had filed separate lawsuits. They had different injuries, but ultimately it made sense to try their damages portion together. And so that's what we did.
Yeah, it was
a little more.
Yeah, no. I mean, yeah, the number of trials, I think, you're ahead of me. I've only had 4 this year, but, they feel like they've been, big results. Obviously, we had the McDonald's chicken nugget, the one that was bifurcated. I got the $5 million verdict in the VI. Now this is what we just had 2 weeks ago. Collectively, for our 2 claimants, it was about 1.614 million was the combined verdict. So, really good opportunity to get in there on a case, which this is where it's interesting because, a lot of times they talk about, the plaintiff lawyers, we're the ones being unreasonable. We were willing to settle this case globally for both claimants for $50,000.
Right.
They said no, and we went to trial. And kind of a nuance about this case. This case was in Miami-Dade. Obviously, our clients, they're 2 born and raised in Miami barbers. They were at lunch, coming home or back from lunch, back to the shop, and there was a vehicle that caused, basically, it was a hit and run incident. We were able to locate the vehicle who was involved in the hit and run, and we did everything we had. We had bystander eyewitnesses that chased the vehicle down. Saw what happened. They ran through a red light. Our clients were perpendicular, causing another client to crash. Now, we talk a lot about trial, but I think we forget sometimes, like pre-trial, you can win a lot of big battles going into trial. Now, this trial ended up being a damages-only trial. Now, that's not how it started. There was a liability defense, but they didn't really defend on damages. And because, I guess the thought is, well, if you're not the person who caused the incident, why do you care how hurt they are? And so in Florida, we moved for summary judgment offensively as the plaintiff's lawyer to say, look, not only is legal causation established, not only is permanency, because in Florida, you've got to have a permanent injury in order to get those non-economic damages in a motor vehicle crash. We basically established all those points, and the judge essentially agreed, granted summary judgment against all their affirmative defenses, the causation for the injuries, permanent nature of the injuries. So the only issue really left at trial was liability, meaning i.e. they claimed it wasn't them, and the damages. Now, in the litigation, they claimed that basically there was no impact. They didn't hit the other car. There's a multitude of, we had cell phone triangulation data. We've got the eyewitnesses. Her job was right coming out of the parking lot she was coming from. She didn't come back to work for a week, couldn't explain her whereabouts ever. And, they kind of hung their head on like, look, there's no damage to the front of our car, right? We didn't have photographs of the front of the car. So we there was an allegation that it impacted the other car that ultimately hit into a head-on collision with our guy. And they basically said it wasn't us. Well, what we found, they actually tried to get summary judgment that we win. When she turned in the vehicle, a leased vehicle, the defense lawyer for the defendant went out and got this information. And what it proved is that this individual was committing a fraud. So not only did she have damage to the front of the car, she had, it was noted by the shop, collision damage up front. And, and we basically presented that to the court as a plaintiff's lawyer saying, look, this is fraud in the court. You see it a lot of times with defense lawyers claiming plaintiffs don't talk about their injuries. They forget about something from a year before, and they get them to dismiss their case. Well, we did the opposite. We said, look, the only thing the defendants can lie about is liability. We have a hit and run incident with all this information. They tried to get summary judgment, and now we know what she said under oath is unequivocally false, fraudulent testimony. And the judge agreed and struck their pleadings and entered a default with respect to liability. So that was it. So all the remaining issues out were out. So we went to trial they had no expert, they had no witnesses, what's interesting is then they tried to play they called it an alleged injury. And it's like, well, no, it's not alleged, the court instruction. So I think that really played into our favor of what was done in pre-suit, because I think arguably if they had defended this case appropriately and had, a defense expert, there were some issues with any case. I think with any trial case, you have some issues. So I think that the work that we did in pre-trial allowed us to get in there and really, kind of fight for our guys, a trial. Now, Jordan, you've obviously tried cases. You were in Lee County for another one, but the jury pool in this particular instance in Miami-Dade County was kind of a unique jury pool, one that I think you and I and the extensive number of trials that we've had have never seen a jury pool like this. You want to talk about that a little bit?
Yeah, I do. I'm sitting here impressed. You have a remarkable way of condensing 4 years of litigation into 4 minutes. Because I agree, the jury selection component was very unusual, something I hadn't experienced in Miami-Dade County before. But I just want to touch on a few things that you mentioned, because the pre-suit process of this case stands out to me in a few ways. And like looking back, Monday morning quarterbacking this, I think there's some lessons to be learned. Unfortunately, we benefited from all of them, but to spot similar opportunities in the future, for people out there, if you do automobile accident cases. So the first one was, this case starts with two guys in a car stopped at a red light, and a Cadillac comes at them and causes a head-on collision. We took this case under the assumption and belief, based on the evidence we had, that it was the Cadillac's fault. We didn't know why he blew the light, came across traffic and caused the collision. And our clients, they're not sitting there anticipating impact at any given moment. So it's not like they were paying astute attention, but our driver client did remember another vehicle passing through the intersection and cutting up the road going north right before the impact. And so we took this case thinking our primary defendant would be the one who actually impacted our clients, and it turned out being someone who cut through an intersection and fled. Someone who, like you said, caused the accident but ran. They never even hit anybody, though. Well, I shouldn't say never hit anybody. They didn't hit our client. That's a weird type of case, because you start pointing your finger at one party, and then based on what they start telling you, this guy starts reporting, it wasn't me, somebody cut us off. You start matching that with what our client said. Well, who is it? And I want to give a shout out to Keela Smith, a senior trial lawyer, an associate in our office. This was the first case we gave her to work up, the very first one. And Keela's an accomplished lawyer, was before she ever joined us, but primarily in the criminal defense realm. So we gave her this, what seemed like run-of-the-mill car crash case. And I think she applied all of her healthy skepticism and investigatory skills to this case, and she was able to uncover who the true at-fault driver was, the most at-fault driver, the one who caused the hit and run. That was no easy task, and I just don't want to gloss over it, because that required getting cell phone location information, having somebody interpret that. That required identifying eyewitnesses. We deposed 2 different eyewitnesses who could corroborate, and that involved obtaining evidence from the dealership where the true at-fault party and ultimate defendant that we went to trial against, where they returned their vehicle. And Keela had to not only find all of these opportunities, but synthesize it into a theory that made sense to get at the truth. And that's 4 years of investigative work that I know a lot of other lawyers might be inclined to just say it's too much, it's too expensive, it might seem speculative. That work single-handedly turned the case from potentially a 0, because the person who actually crashed our clients head on may not have had much fault at all. A jury may not have seen any. Turned it from a potential 0 to this hero verdict. And so I want to give credit where it's due in that component part. Then you mentioned some of the pretrial rulings, and I think it's important to give credit where it's due. I think summary judgment is too often viewed by plaintiffs' lawyers as something that they have to be on the defensive about. because they're accustomed to defendants using it to either throw out all or part of their case. And customarily, that's what the majority of the summary judgment motions are aiming to do. But there is no rule that prohibits plaintiffs from taking advantage of the same mechanism. And so our firm really tries hard to identify those issues. It's never going to be the whole case. There's no such thing. A judge, I want summary judgment, says I win for this amount. That's not a thing. But cases have issues of duty, breach, causation, damages, permanency, as you mentioned, all of these little but significant components that we ultimately need to prove. And if you catch a defendant, to John's point, who's really only focused on liability, for example, and they're not really building up a defense for causation, damages, and permanency, that's a good opportunity to seek offensive partial summary judgment. And you guys did that successfully. I wasn't a part of that litigating pre-suit, but I was aware of it. And then the last thing I want to comment on pre-suit, which is highly unusual, I have never had it happen, so is the fraud on the court using that offensively. If you have ever practiced personal injury law, especially in Florida, and especially in South Florida, Miami-Dade, Broward, and Palm Beach, you are unfortunately all too familiar with some of the defense lawyers' tactics to seize any opportunity of like forgetfulness to pervert that into fraud. Somebody's deliberately withholding, they're trying to perpetuate this scheme on the court, undermine the integrity of the proceedings. They want to throw your case out any which way they can. So we're always putting the defensive. You know, client says one thing in a deposition and a medical record from 10 years ago says something else. They want to cry fraud, even if it's just honestly forgetting. In this instance, we had a defendant who lied, said that to you, you just said, oh, even though that may have been my car, I wasn't there, caught in a lie. My car had no body damage, caught in another lie. And we use that to package it to the judge. And there's a great concurring opinion out of the Second District Court of Appeal, and I forget the judge's name who wrote it. So not binding, but persuasive, that from a few years ago, it said, this particular doctrine, fraud on the court, should be applied equal-handedly. It's most commonly, we see it being used by defendants to throw out lawsuits, but if a defendant does commensurate misconduct, they should have their defenses thrown out. And that's what happened. This judge had the decency, candidly, to do what the law required, what was fair under the facts and what the law supported. And even though it's an unusual ruling, it was the right thing. And so I just, it took 4 years to get to trial. Yes, COVID was a part of that. But I think the lessons to learn here are make the most of the information that's available to you and make the most of the time that's available to you. Because, the work that Keela and also Diana, the paralegal that works with Keela, this was also Diana's first case at our firm. The work that they did on this case is so remarkable. I don't know. I think we could go another 10 years. And this is not to minimize anybody's ability. It's just so unlikely that you could take a potential nothing or low value case because of liability issues and turn it into this $1.6 million thing. So I just wanted to touch on those things. So yeah, jury selection. Let's flash forward a bit, because every case with a jury needs to start with picking it. And John's right. This case is in, for the trial lawyers out there, this may just be ingrained into your brain. But for the people out there who are lawyers, maybe you're transactional or you're a law student thinking you want to be a trial lawyer, venue. You can have the same case on the same facts. And if it's in two different venues, even in the same state, especially Florida, you might get two completely different outcomes, right? So this matters who's in your jury pool, basically. And in Miami-Dade County, we've tried a ton of cases there, maybe more than most of any other venue. We had come to anticipate that the veneer, the panel of prospective jurors, would run the gamut between age, race, ethnicity, education, sophistication, whether they're transient or born and raised, you name it, because they're pulling from all of Miami-Dade County, and it's a global melting pot. It's a diverse place. This jury panel was the complete opposite of that. I won't guess and say what it looked like, but this is what it was. It was predominantly white, if not almost exclusively. Almost exclusively people who were, let's say, 28 or older, and leaning on the older side of that spectrum. Almost entirely people with substantial educational and professional, trade history. Many of which, I want to say half of the pool was like C-suite executives, CFO, CEO,
Yep.
president, owner, all business, owner. And the people that didn't fit the C-suite, they were, we had an insurance fraud adjuster. We had another insurance adjuster. We had an insurance defense lawyer. We had a retired insurance defense lawyer who knew defense counsel. This was like highly, highly unusual. And then when you put aside that and you get past like the initial gasp, you still got to pick a jury. So, John, maybe you can talk. We did secure Mary Sheedy. Shout out to Mary. We tried to avoid trying cases without jury X these days. They're just great at what they do.
Yeah, I just, the more we try cases, the more like, I like to have someone that can find out information about them. You don't get that in federal court, which I think, they literally like turn off the internet, which I think is such a crock of shit, to be honest with you. I mean, like, don't find out who the jurors are except for what I ask. I just, I never understood that. It's like, just because I'm in federal court, I'm an Article III judge in an Article III court, we have to really decline the ability to get a fair and impartial jury, which is really a constitutionally provided right, to have a fair and impartial jury. So, yeah, I was asking the questions, and, it was a tough panel. I mean, I think that, we had a Supreme Court justice's brother on there. I mean, we had a bunch of doctors, but some people are like, oh, I deal with all these like fraud, workers' comp cases. I was like, and it was without having like, jury X or a consultant to help assist with some of the stuff, to find out information about who we're like on the fence about. And
do you remember that game Minesweeper way back?
Yeah,
dude, that's what it felt like. You were up there asking questions, and it felt like all of them look the same on some level. They all are similar enough. I don't know which one has the mind under them or not. It was a very big challenge.
Yeah, I felt like I clicked the first space and hit a bomb. Like,
That's really what it felt like.
But yeah, I mean, it was, it was challenging to get through it. We kind of picked like, so I think that we had a more conservative juror than I've been accustomed to in Miami. But that being said, the fact that we, because we didn't have those other issues to deal with because we addressed them pre-trial, it's not that big of a deal, but had they had an expert and could talk about, the gaps in treatment and all of these other things, it may have presented a problem. So we kind of had like the comfort knowing that the work that we had done allowed us to come in there and say things like,
it didn't hurt. Let me just say, it didn't hurt that although we had to fight for it, the judge was very reluctant, but she ultimately did what the law required. We were able to have 6 peremptory challenges going into this, not 3, because we had 2 different clients.
Right.
And the law in Florida is each side gets 3 peremptories unless there's multiple parties that are not basically identical in interest on one side. And if so, then each side has to get, you just keep going up proportionately. And here we had 2 separate plaintiffs. So I just wanted to point that out. It did help. Had we only had 3, we might have been up shit's creek. 6.
Yeah, we might be having a very different podcast.
Can we use all 6?
We used all 6.
Yeah.
And I think we used one for an alternate. I mean, it was just.
Yeah. And let me say something else about the jury selection component. And this is for years, because you just didn't have, or we didn't have the resources and knowledge to know the benefits of a jury consultant, because they're varied. They're not just like it's not some out of the box secret sauce. There's no crystal ball. But one of the things that they do, and Mary in particular, and it's very calming, and it allows you to really concentrate on strategic decision making as opposed to tedious note taking, is we have a court reporter there, obviously. Shout out to Jeannie Sanchez from Jeannie Reporting. We use them whenever we can for trials. Jeannie brings real time. What does that mean? Real time is she will set up these mini iPads so that in real time, the judge and us and opposing counsel, we can all see the transcript. It's a rough, she's typing contemporaneously, but it's pretty damn accurate. She's great at what she does. So we can see a transcript. So this means I don't have to take notes like I normally would. And Mary, our jury consultant, doesn't have to type her own notes. So everybody can concentrate on active listening and then take the same information and interpret it however we're going to, process it, and be able to give strategic insight, as opposed to, did he or she say this? I'm pretty sure. I'm not sure. It's like you could just control F and find it. And I just want to point this out, that if you're not using real time in trial, we only use it for jury selection. So let me be clear. But if you're not using that in jury selection, I think you're putting yourself at an extreme disadvantage, because otherwise we always used to tease Keela that like she's an exceptional note taker, but you're so distracted when you're doing that. So anyway, I just want to point.
Yeah, I mean, because they get like the timestamp, so you can go back and call it up and pull it up when the judge has a question on a cause challenge, and you could see it right there with the timestamp. So that I think is really helpful.
What's your biggest nightmare? Judge, I'm moving for cause on juror X because she said this. I don't have that note.
I don't have that in my notes.
Right. Everybody's heard it.
We've been there. Case got denied the cause challenge, lost the trial, went up on appeal. And sure enough, they're like, it was right there, and you should have granted the cause challenge. So it came back. So like, it can
real
help
time,
you.
real time, real time.
Yeah, it can definitely help you. No, and it's funny you were talking about active listening, and I don't know if my brain hurt. This was one of the trials where actually like people were cracking jokes, juries laughing openly, like with everyone, which is very unusual because in the sense that that's generally not how I portray it in trial. I'm like, look, this is serious from drop, right? But our client's persona was like, he's a fun guy. He like wants to be jokeful with with the jury. But there was a part about the active listening where I was doing Dr. Nicholas Sweet. He's our neurologist, and he brought out the iPad, which is actually pretty cool. We connected it, started drawing on there the brain, the various components of the brain to talk about the brain injury. And we talked about the different lobes and the functionality. And I guess I missed one of the lobes he went through, and I was like, "All right, Judge, but what about this lobe?" He was like, "Oh, I already did that." I think Jordan actually made a comment.
I had to
Yeah,
miss the opportunity.
Something about I had a brain injury, and like the jury laughs, and like I was like, "Oh, sorry, doctor." So it was a very, sometimes those humbling moments in front of the jury look good, especially when I get up there and I'm, I asked for $7.2 million or whatever I asked for my client, and that's how we broke it up. So I represented one client, Jordan represented the other, and that's kind of how we did, which was good, but also bad because I like to confer with co-counsel before I sit down with the witness every time. And there were times like we wanted to keep up that presentation. So I didn't confer with Jordan, like, moment to confer with counsel because we were technically co-counsel, but we wanted to give the appearance that we were separate. So, that was I don't like to be alone on the island because I don't pretend like I know every answer, or if I think I missed something or if I didn't, and actually Jordan wrote me a note because I missed something and got it out on redirect. And I did the same for him, like kind of the buzzwords with an expert of a question.
Yeah, it's a delicate dance, but ultimately, I think every trial starts from a strategy standpoint. We know the objective. The objective is to win. So it's easy. The hard part is deciding strategically how to execute. And you and I, kind of late in the race, decided to do something we had never done, which was to each represent independently each plaintiff, and to the extent possible, keep that wall. Not while we're prepping, behind the scenes at night or during recesses, but in front of the jury, because there's two components to it. We believe that from a persuasiveness standpoint, it would give a bit more legitimacy, although there's nothing illegitimate about it otherwise, but a bit more legitimacy to each individual's claims. And it would reduce the likelihood that jurors would muddle them together or think it's just one big ask collectively. So we wanted to avoid that. And the second thing is, we have a habit in single plaintiff trials of like, all right, you're going to do this, you do opening, and then I'll do this direct, you do this cross. And from lawyers, it's easy to, assign the roles. But I often think about it from a juror's perspective. I imagine like maybe they want to hear one of the lawyers, one of us versus another, do a particular thing, and then we don't give it. So this was a unique way for us to deliver, to divvy up the work. And even though we had multiple witnesses, we didn't have to do multiple examinations, but we did do multiple opening statements. So that was unique. So this is the way that the judge decided to do it. And I think it was the right way, but it was John went up and presented the opening first for his client. And he did a great job with a PowerPoint presentation of walking them through everything they're going to see and hear. Then he stopped. Then one of the two defense lawyers, because they kind of divvied it up the same way, she got up and did her opening as it related only to John's client. Then I had an opportunity to get back up for the second plaintiff, the driver I represented. I gave my opening, and then the final defense lawyer did theirs. So that's unique. We had never done that before. I do think logistically it worked fine. Clearly the jury understood who represented who. And I think right from jump, it allowed the jury to split the plaintiffs into two camps. But quick side note here, I successfully, thankfully, passed the Virgin Islands bar examination, but in order to get licensed down there, I have to finish by doing a personal interview with some members of the bar. And they had scheduled me to do that during day one of trial. So I knew exactly when it was going to be, and I told them I'd be in trial. And the way I thought openings would go would be John goes, then I go, then the defense, and then the defense again. And if we had done it that way, I would have had time to step out and take the call. But the way that the judge ended up doing it, which was much better for case presentation, put me in a position where when I stood up, I had 23 minutes to get up there, say my client's opening, and sit down and simultaneously jump on a Zoom and walk out the door. I went 26 minutes. By the time I walked out to jump on Zoom, the board, the bar governors, whatever it is, they had they didn't want to see me anymore, so I have to reschedule it. So that was one detriment, but overall it worked out fine. And I know the bar thing will too. So let's go forward now. We've given opening statements. Now we have to call witnesses. Every case, at least in our world, personal injury case has two basic types. It's fact witnesses and experts. Experts in our cases are going to fall into one of two camps. They're either like medical, meaning causation, what types of injuries happened, what caused them, and damages, like how bad are the injuries, will they be there forever, what future care will be needed, if so, how much. And then you got fact witnesses. Hey, like an eyewitness, I was there, I was in the car, this is what happened, this is what I heard, this is what I felt. Best done by our clients. And then you've got other fact witnesses, like before and after. People who say, you know, who can say with confidence, I've known the person before, so I can tell you what their condition was, and I've known them after. This case had all of that, including independent eyewitnesses. John played the video deposition of one of the people to testify that the defendant we were suing did cut off that light. Like he actually waved her ahead, go ahead, and then to his surprise, she blew a red light and caused the whole thing. So from a professional, like an experiential perspective, this case had it all. Even though it's an automobile crash, it had everything you could have in a personal injury case, every type of witness. I guess short of like an accident reconstructionist on liability, because that wasn't that issue, but we still got everyone to testify. So let's talk about experts, because you were talking about Dr. Nicholas Sweet. He's a neurologist who treated your client only for the mild traumatic brain injury. Can you spend a little bit of time, because we say mild traumatic brain injury, and I don't know who our audience is, but if you're a personal injury lawyer on the plaintiff side or defense, you probably are familiar with this diagnosis. But if you're just a lawyer in law school, you might not, and you might just incorrectly assume that it means one thing when it means something else. So can you talk about the difficulties and challenges of presenting an MTBI case?
So, I mean, look, the problems associated with a mild traumatic brain injury is that the plaintiffs look normal. They look normal, they sound normal, they generally talk normal, and the imaging, for the most part, you know, meaning CT scans and MRIs, are normal. Everything's normal. And, you know, that's kind of their big thing, is they say normal, 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 normal. And so you've got to kind of bring, I think people have a general understanding now that, like, look, you're dealing with a traumatic brain injury. I mean, you're dealing with these neurons at such a, you know, microscopic level that they can be injured and damaged. What we saw, you know, in football players, they didn't see until post-mortem under a microscope. So, you know, what I kind of start, this is how I determine, like, basically, if you've got a major impact, and this was a major impact, and you've got a loss of consciousness, you've got a brain injury. Or really, the CDC describes it as an alteration of the brain function, right? And there's basically there's four reasons or ways to do it. One is a loss of consciousness. But again, you don't have to have a loss of consciousness. You can have, like, you're confused or dazed. You know, that's another one of the category. If you've got retrograde amnesia, meaning you don't remember aspects of the crash. People sometimes get hit, you know, and then they don't remember. Like, I have no idea what happened. I just woke up at the hospital. Like, that's a brain injury. You know, what makes it kind of the mild traumatic brain injury is that the length of time in which the symptoms continue, right? Like, a concussion is a traumatic brain injury. The problem is sometimes they resolve if it continues. And the studies have shown, there's a study that there was a 2019 neurological article that I use, where they followed individuals who had brain injuries that presented to level 1 trauma centers. And they found that of those individuals, 50% were still experiencing symptoms 1 year later. You know, and that's kind of the mark. If you're still experiencing those symptoms 1 year later, you know, and it affects nearly every component of you know, of the brain. And then, but it also depends on, like, where in the brain, what is the dysfunction. A lot of times you see the frontal lobe injuries, you know.
When your client was in his late 20s, he's a young man,
right?
Like, fit, like, in shape. From, like, an outsider looking in, there's nothing about this guy that says he's injured, let alone has a brain injury. So he came in, his girlfriend, the mother of his child, came in, and they tried to shed light on, like, the things, like the nuance that only they would know, right? But could explain as best they can, like light sensitivity, irritability, or like lack of patience with the baby now, headaches, these kinds of things. These are the things that, like, yeah, it's easy to just toss them away, right? Defense lawyers toss them away, like it's not on the imaging, it's not on a CT, it's not on an MRI. But to John's point, it's our responsibility to elicit from our clients or the people that know them, not just experts. This is really how it's affecting me. And I'm a young man. I'm scared it's going to get worse, that kind of thing.
You know, in our brain injury case, what a lot of times they want to find, and one of the things, I think Dorothy Clay Sims has got an exceptional book on, like, deposing the deceptive doctors. And there's like a 2-volume pack that literally for every type of doctor, but really a lot of times on the neurologist, the neuropsych, and the brain injury side, because these doctors say, well, it's not from this. You're like, okay, well, let's go through her symptoms. And what I do, and I like to do this, is I say each and every one of these symptoms falls under the umbrella of a traumatic brain injury, right? And I say, okay, so you said it's not the traumatic brain injury. I was like, give me the diagnosis that she has that would account for every single one of these symptoms. And they're like, I can't give you one. So like, so that's the idea, that they don't have an alternate story. They say defense lawyers are paying me. I just gotta say it's not this. But then, well, what is it? I don't know. What is the
Well, that's the key,
most...
just so you know, like for the practitioners out there, there's a difference between what we know as plaintiffs lawyers. Like we know it's a higher paid for opinion. We know that, but we can't just tell a jury that. That's not going to land, because this is a professional coming in, often a medical doctor. So to John's point, it's about boxing them in to say, like, you're saying it's not from this, it's not from that, it can't be this. What on earth has all of the evidence? Like, what else would fit all of the evidence we have? Nothing.
And we had that in the case, and I finally had her admit that the client had a mild traumatic brain injury. You know, at deposition, which she described that I was firing bullets at her through a Zoom screen. Jordan's like, wait, like that's how you felt through a computer screen? You were so scared. She was like, I was terrified. And it's like, no, you had to admit, you know, that's the thing. And you get them into a position, and yeah, you can't say the hired gun, but when you show how much money some of these people make, what you do is you say, okay, this is your opinion. You show how ridiculous it is, and then say, isn't it true you've been paid 50 grand in this case? You know, I have a case where, you know, separately, a doctor for the first time ever in my career said, if the injury event did not occur, my client, despite not having years of treatment, was going to get all of this, the next 10 years that she's been undergoing treatment, she was going to get that anyway.
Oh, that's a good.
I've never had a doctor do that, and that's all his real, like, his opinions are. I don't even know what his expertise is, but he's been paid almost $40,000 already, not including trial. So by the time he comes to trial, I'll be like, isn't it true you charged $50,000 for this case? You know, and I think the jury's going to get that. I said, because I'm going to ask him in front of the jury, what's the winning lottery tickets for the Powerball drawing coming up? I was like, you're psychic. You obviously can read the future, so I want to know what are they? I'll get an objection. I'll get it withdrawn, but.
So in the trial that we just had for my client, the driver, what was pretty interesting, and I thought might have been a problem. Now the verdict tells us it wasn't, because the jury was sophisticated enough to parse it out. But going into the trial, I thought it was going to be a problem. Was this? My client, the driver, definitely lost consciousness. In fact, the passenger, John's client, testified in deposition and then at trial that when he looked over after the crash, he thought my client was dead. So if anyone were to have a mild traumatic brain injury presented to the jury, you would think it'd be my client, because obviously the loss of consciousness qualifies. But my client didn't pursue that, so we didn't present it. So we had this case where the best eyewitness evidence of who lost consciousness and probably should be the TBI was not the person claiming it. It was the person who was required much more subtle and nuance. Then you've got a situation where my client hurt, obviously his head was banged up. He had marks on it. We had photos. He hurt his neck, sore, obviously. It's a huge impact. He hurt his right knee. It was swollen. We had pictures of all the bruising. And he hurt his ankle. And not just hurt it, he had tears of 3 different ligaments. He developed post-traumatic arthritis in it, but he's a barber. I bring up the barber because he's on his feet all day, so the defendant tried to seize on that. But this was the first time I had a case where I just walked into trial, and obviously with my client's blessing, and he understood strategically, it made the most sense. Could I argue he still had a traumatic brain injury? Of course. Could I argue the neck was a big deal because it lingered for a while? He had to do like 38 PT visits before it truly resolved? Of course. Knee, same thing. His knee was swollen. It still kind of gives him issues. But I wanted the jury to focus on what was most significant for him. Because I think by focusing the jury's attention, you increase the likelihood that they'll understand it. Whereas when you dilute their attention and you're asking them to consider all these different body parts, some are permanent, some are not, I think it loses its efficacy. So in this case, I strategically told them it's really just an ankle. So we didn't hire, he treated with a podiatrist who we then paid to come in and testify, Dr. Jamie Carbonell. And he did such a great job explaining the significance of the injuries, how they could not have been caused by just normal wear and tear, by being a barber standing on his feet. Our client had previously testified that before the crash, he was active. He was a former baseball player. So now he's in like adult softball leagues. He was in adult basketball leagues, regularly participating. And, you know, his mom and girlfriend talked about that. But he couldn't do those things anymore. So the defense tried to like use our expert, the treater, to say, well, couldn't have been from jumping and sudden moves. And, they were trying to make what they could of it. But Dr. Carbonell did a great job explaining why none of that could be cause for it. My client did have plantar fasciitis on the bottom of his foot where it connects to the heel. And that definitely could have been caused by his job, but none of the other things, they were all traumatic. And he had been recommended surgery. He had multiple injections just to temporarily help with the pain. He had been recommended multiple surgical procedures. One was a scope, an arthroscopic surgery, more limited in downtime. He could get back on his feet quicker, literally and figuratively. And that was a big deal because, we didn't make a wage loss claim in this case, but he is the breadwinner for his family. So having some substantial surgery when you're a barber, nobody's paying you when you're not working. So it was a big consideration for him beyond also the natural apprehension and fear we have asking to be put under the knife. It's a big decision to make. And he never got the surgery. And in fact, in my client's case, there was like a 2-year gap where between his last consult with Dr. Carbonell said you need surgery versus when he went back to even get a second follow-up. We had a pandemic for about a year of it. I thought the defense did a pretty effective job of explaining, they want to make a big deal of the pandemic, but that was only a year. What about the other 12 or 18 months, whatever? I think they did a good job, but the jury saw, this was our position, pretty simply. Once a doctor tells you you're permanently injured and the only thing that's going to repair you is surgery, you don't need to go back every week, every month, or even every year. You really only need to go back when you want the surgery. And so that's kind of the thread we pulled on it. Ultimately, I want to now kind of come towards the close of the case to be respectful of our audience's time, because you and I could spend all week talking about it. But there's two components. We gave closings. John used a presentation, like a Canva or PowerPoint. I chose not to. John asked for, and understandingly so, he had multiple body parts. He asked for substantially more than I did for my client. John asked for a little over 7 million. I asked for a little over 2 million. So the jury kind of had this interesting dynamic, 2 different people, 2 different lawyers, 2 different presentation styles, 2 different asks. And it ended up working out just fine. Mary Sheedy predicted accurately, as she usually does, who the foreperson would be. She was right. And it was a great outcome. Obviously, the verdicts speak for themselves. I mean, they're substantially higher than the clients ever got offered. They're nearly, basically $800,000 a piece, which to me is a significant sum of money. And it's potentially life-changing money. And I don't mean that in like a lottery sense. I mean, they can get the surgery and the care that they need. They're not going to have to worry about the things that they shouldn't have otherwise had to worry about, but for the crash. So.
Yeah, I mean, it was an interesting thing. I think the jurors. So the night before we had closings, one of the jurors do we even need to answer all the questions? Can we just write a number at the bottom?
I was the law firm administrator, who I don't want to mention.
Well, when you say administrator, he's the guy who runs the firm. He's the COO.
Massive AM law firm. I don't even want to say how big. He runs the whole thing, and he was on our jury.
So yeah, he's gonna have a good story, at the holiday party about having him serving as a juror. But I think they in a jokingly manner said I was crazy for how much money I asked for. But I mean, when I break it down, it's not really that much. I like a per diem argument. I give a formula. I did 3 separate injuries, so I had
the formula. They said,
yeah, they called it the Fischer formula, which was funny. And then Jordan and they were like, but it made Jordan seem more reasonable when he had 1 injury, I had 3, and he asked for 1/3 of what I asked for. So it's it doesn't make sense to me. So they ended up doing what we didn't want to do, but they basically gave the clients nearly the same amount. I think definitely for the non-economics, they gave them the same, which, that's just I don't know. Juries are, I respect everything the jurors do. I do my best to present it, but I think it was a great result, like Jordan said. And it's true, because we filed proposals for settlement in Florida, which means we clearly got more than 25%. I mean, we were willing to take $20,000 and $30,000, and the insurance company said no. And to date, they still never even offered the policy limits. They kind of were like, well, if you'll take it, we may get them to offer it. I'm like, that's not how it works, man. You guys are the one that did this. So we're potentially looking at tacking on another, 400, 500 grand in attorney's fees on top to get that thing over 2 million. So imagine that an insurance company could have paid $50,000, tried to push us to trial, and they get hit for 2 million. And that's where it's not the plaintiff's lawyers that are not we're the ones, if we try to be reasonable, and then you're just we'll go see. And then what happens? Then you get kicked in the mouth. You're like, oh, juries are out of control. No, this is what you asked for.
Right.
People of the community recognize life is precious. They know the insurance company's bullshit. And I don't think they're putting up with it anymore. and they've got a taste of what it feels to be locked down in your home and taken away and not being able to go out. They all had those personal experiences they had during COVID. So I think when someone's stuck in their house and not going to do those things, and that's taken away from them, they can kind of sympathize, or maybe I should say empathize, because they've been in those shoes. And I see we're seeing bigger and bigger verdicts. And, I don't think it's a coincidence at all. So.
Me either. Well, like I said, we could probably talk about this for a week, but let's be respectful of our audience's time. It's been a while since we did one, so we wanted to get this out timely based on when the verdict was rendered. So stay tuned for future content. We're going to be trying to put it out every other week, get back to our normal cadence. And as always, if you have any questions or if you want to recommend a guest or you'd like to hear join the podcast, we're always open to input. You can email marketing@yourchampions.com or just DM us on any of our social platforms. So that's it for now. Tune in next time. Thank you.
All right, guys. See you next time.
1, 2, 3, 4.
There's nothing more thrilling than nailing an insurance company.
And the truth shall set you free!
I want the truth. You can't handle the truth.
Great moments are born in great opportunity.